Good morning. Welcome to the special call meetings of OPS. I am Marita Davis Johnson, the chair of OPS. The members that serve on the committee with me is Commissioner Robert Patrick and Commissioner Ladina Bowden, which we expect her shortly. We also have Commissioner Ted Terry here with us this morning, so welcome. And so with that, we're going to discuss 2026 state legislative agenda today. And so I was told that the CEO would be here to give remarks at the beginning of the meeting, but I think Martha is going to do that in her stead. So good morning, Martha.
Good morning, Chair. Good morning, Board of Commissioners and staff. So Madam CEO sends her regards. She is not able to be here this morning, but I do want to make a couple of notes and on her behalf. So first and foremost, we just want to thank the Board of Commissioners for this long-standing journey with us. This is the first joint legislative work session between the CEO and the Board of Commissioners where we were able to come together and talk through the legislative process. So right after the governor signed the bills in May, we started having these conversations about having a joint session together. And so in our joint session, we were able to lay out the groundwork for identifying the county's legislative needs. So Madam CEO and all 7 commissioners were able to present their legislative priorities, and then they were able to actually vote on their top 10 and their top 3. Staff tallied, so BOC Central staff worked on tallying the results, and they were shared in the last Ops Committee meeting. Upon that, some items fell into one of the 3 categories, and I just want to make sure these categories, we talk about them throughout today's session. Basically, what can be handled locally without any state legislative changes? What is identified that's not a state issue, more of a federal matter issue, and what did not meet the voting thresholds or need any further review. So those are the categories that they were broken down into. And this basically will drive the core of what we have for next legislative session. Back to the first BOC retreat, we did adopt some guiding principles that we were able to discuss during our legislative session that we had together. And so from there, staff, Denton's, and the legal team, along with BOC Central staff, they were able to condense all items from 16 to 10, and they will be talking about that a little bit more, and then to top 3 based on the votes. This framework obviously mirrors ACCG's statewide legislative process, which has been an effective model. So on behalf of CEO, she really thanks the Board of Commissioners for being open to adopting a similar process. And in addition to that, she wants to remain committed to working alongside the Board of Commissioners on this for next year. After we move forward with this clear map for action, she will create a packet for us to present in front of our legislative, both the Senate and the House side. We will have the delegation lunch or dinner as we had discussed during session. So those are all my notes. Again, she wants to thank our ops chair for leading this discussion today and making this happen as we move forward. Thank you.
Thank you, Martha. And you know, I'd just like to say that this is the first year that we ever had a joint legislative work session between the CEO and the Board of Commissioners. And I think it's a significant milestone showcasing the power of a unified and representative government. And so with that, I would like to thank our CEO, who is not here, but I'm sure she's looking, so I'd like to thank Madam CEO for her leadership and vision and helping making this joint agenda a reality. And just wanted to make a couple of points, and I'm sure that Dan will make them also, so I'll just name them out. The standards for legislative priorities, Dan, and welcome, Ladina, Commissioner Bolton. Create the issue-based adopted platform, and we really need to talk about the home rule issue and the review process and the approval process. So I think with that, Dan, I'm gonna bring you forward. Are we at a good place with that? Okay.
Good morning, Madam Chair and committee members. Dan Baskerville, the Dentons. It's been a long time since I've been in this committee room. So what you have, I believe, in the package that central staff handed out to you is a document that is titled Proposed Legislative Items for DeKalb County's Legislative Agenda. And it first gives a methodology, because Martha just really gave you the background of kind of how we got here, but it gives you the methodology for how we came up with the first 2 pages of that document are the 10 items that are recommended to be based on the work you all did for legislative priorities. So as was discussed at your work session, the goal was to hopefully have 3 top priorities, and then the rest of those on the list would be what we call policy objectives, which are basically in the same category as priorities. And then anything not in those categories, when you go to page 3 of the document, I guess it's double-sided here, page 3 on the top, it says support statements. So that would be everything else, and that would be, stuff, it would be basically be the county's position on a bunch of other items, but wouldn't be the legislative priorities, but it's something that we could also work on at the General Assembly when stuff comes up on those issues. But to try to narrow the focus of priorities, it would be the top 10 items from page 1 and 2. And I guess one of the questions before you today as we go through this meeting is deciding if you, as we've discussed before, trying to narrow that down to 3 top priority items from that list of 10, and everything else would be the policy objectives. So I'll defer to you on how you want to proceed with that. I'm happy to go over each one of them and just explain those top 10, if that's helpful to start with.
Okay. And let's do that.
Okay.
And does anyone have any comments or questions before he gets started? Okay. Okay. And so the top 3 that we have listed here are the top 3 that we pretty much voted?
Well, there's some distinction there. So the way I group them is, so the sheet you have in your package that has the bars, which you saw at ops the first time, that has the number. So if you remember back to the work session, you all voted on you put your top 10 list in, and then from that you picked a top 3. So for example, item number 1, the comprehensive property ownership database, that received 3 top 3 priority votes. Then items number 2 through 6, they received 2 top 3 priority votes, and items 7 through 10 received 1 top 3 priority votes. So going back to what you said, it's not necessarily 1, 2, and 3 on the sheet received the most. Number 1 received the most, and number 2 through 6 all had the second most because they all had
The same.
2 top 3 priority votes.
Okay. Okay.
And if that hasn't confused everybody, because I know this is a new process we're doing, and there was so many items and everything that we're trying to break it down into this understandable list, but it's still, I know, maybe if you have questions, let me know how we came up with that, but it was developed from what you all voted on. It wasn't just, created out of thin air or anything like that.
Okay. Okay. Did you have something?
If you don't mind, Madam Chair, I do have a question. So on this page right here, just looking at technology fees was the 3rd item. But when we flip over to the other page, technology fees is, I think, 7 or 8 in the list.
Correct. So if you look at under the methodology, where we talk about how we narrowed it down, about where it says the items that were removed were either because they can be accomplished locally without amending state law.
I see.
And that technology fees falls under that. After consultation with the county attorney's office, that is something that can be done without a change to state law.
Just for clarification, I thought the county had a technology fee in years past, and we did not win a lawsuit. Is that accurate? And so that's, if you guys will look into it, if you could confirm that. I'm fine with that going to home rule. It would be much easier, but I just want to make sure we're not creating another opportunity for a problem for ourselves. Okay.
Yeah, I'll defer to them on that. And I know we consulted with legislative counsel at the General Assembly on it too, and they also believed it could be done locally.
Okay.
And what was that?
That was the technology fee.
Okay.
Another way to help pay for the technology our staff is going to need to modernize and be more efficient. So, thank you.
Okay. Okay.
Thank you, Madam Chair. For the top one, the Comprehensive Property Ownership Database, parentheses, rental registry, did y'all determine the distinction between the database at a local level and then the actual registry, which I think is the intent of the state law change, and what we can do on either front?
Yeah, so Commissioner, the state law on that is pretty clear that what we cannot do is require people to enroll in a rental registry. If it is possible for the county to determine who is an owner and who is a tenant through other available means, as we've discussed, there's no prohibition on the county determining that information. But what we cannot do under the existing state law, as we understand it, is require registration of those rental properties.
Okay, and I guess maybe the one caveat to that, Dan, is that the investor-owned properties, I think over a certain number, have to now register rental properties?
They don't have to register. What they have to do is they have to have an agent on file. It was a Representative Mary Margaret Oliver's bill that requires that they have an in-state person, so if there's complaints about the property, they can get a hold of somebody, so, but they don't have to. So sort of a registration.
Okay. Well, and I think that's, I would just suggest that as we go through this list, Madam Chair, we sort of get to the point of why we're trying to do it. And so if the comprehensive property ownership database is really about addressing absentee landlords, which in my experience, it is the investor-owned properties that sort of haven't been available for code compliance or other sort of, neighborhood complaints, that's sort of the crux of what we're trying to accomplish here. Versus just saying every property has to register commercial, industrial. I mean, it almost seems like we're sort of duplicating things that we already know, to the point earlier, Attorney Welch, about a database. Because if we know how to contact someone, that's hopefully the issue is, will they respond? And if they aren't able to be contacted, do we require them to be registered so we can contact them? And so I'm just curious, has GMA changed any of their, because it says here it's being pushed by GMA, it's part of ACCG platform, but how does ACCG and GMA view this in light of the investor-owned properties? Is there another piece that we're trying to solve with this legislation?
I think they would like, a comprehensive approach. I mean, for example, for Representative Oliver's bill last year, they wanted to roll, and her bill at the beginning was closer to requiring what you originally said, but she changed it through negotiations during the process, and GMA actually wanted to roll that language into their bill, but she felt it was going to run into trouble, so had a more narrow approach with her bill to try to get that done. But I think they're looking at all of those, the investor-owned and everything. And that was a big topic of discussion at their policy committee meetings, is, some of these communities around the state where they're having significant issues with that. So I think all of it is on the table.
I would just like to add and ask, in addition to what, because my whole premise has always been a registered agent. Because I would think what people would need would be a source that if there's a registered agent, if you serve that registered agent or contact that registered agent, it would be just like contacting the owner, and you wouldn't have to look for the owner because they have registered an agent. Now, would state law prevent the designation of a registered agent? Because whether you are a investor or an owner, if you live out of town and no one can find you, you still have the same problem. And whether you commercial or non-commercial, you still have the same problem with getting process of service on an individual. And so my intent has always been not so much, I don't have an opposition of a database, but my priority was a registered agent, because the problems that these neighborhoods are encountering could be resolved through court if there was someone to serve, but they cannot find the owner. And so that's what my priority would be. So Dan, is there a problem with a registered agent for properties rather than owner registry? Required to register.
So, ma'am, Dan, sorry to jump in. Okay. Under existing state law, ma'am, a corporation that exists outside the state of Georgia but is doing business here is going to have a registered agent registered with the Secretary of State anyway. I think what I'm hearing in the nuance here is that you would like a requirement that that information be provided to the county, so that we are aware of who is the registered agent for those individual properties. I'll have to look at that nuance to the question. I'm not aware of anything as I sit here today that would prevent us from requiring the name of a registered agent to be provided to us, but I'll have to double check that.
And so a sole proprietor does not have to be a corporation, and a landowner can be a sole proprietor.
Sure.
And we still would not have a registered agent for that person.
My understanding of current state law is they would not be required to have a registered agent if they're an individual owner
Yeah.
residing in the state. Yes,
Yeah.
ma'am. So that would be a legislative change, most likely, to require that, and then to require that information be provided to us.
Okay, thank you.
But in terms of the corporate ownership, I can check to see if current state law would allow us to tackle at least that one piece of the issue.
Yeah. Okay.
Thank you, Madam Chair. I guess this question might be for Zach. When we have people that open up utility billing accounts already, are we not capturing the property owner's contact information in addition to the tenant's contact information? And if we are getting that, does code enforcement have access to that list of property owners? Can it be intertied with the property tax records? And then, as our chair just mentioned, even Secretary of State data. Put another way, the legislative effort aside, are there things we can do on our own that we can build our own database, if that means hiring a data acquisition firm that can put everything together for us?
So when a tenant,
Mike?
when a tenant opens up an account, they would provide a copy of the lease.
Which would have,
So presumably that would have the owner's information. We don't specifically ask for owner's information, but I do believe that would be contained in the lease. And so with that being said, we do have owner data,
okay.
potentially owner data, but certainly tenant.
Perhaps if there's a way that on the administrative side, you guys can start actually adding that to the database information when you open up utility billings, that might be a first start. Again, the legislative priority is still there, but this might be just something we can do exclusively ourselves. Thank you.
Thank you, Madam Chair. Yes, I agree with Commissioner Patrick, and I think that's part of what we were discussing last time is a registry is requiring someone to register. A database is whether we can maintain it legally and all of the sources that we have, right? So, for instance, in this statement, it's saying that a comprehensive registry list of all types of property, including non-single-family residential, multifamily, commercial, industrial, vacant land. Presumably, multifamily, commercial, industrial have to get business licenses, for instance. So if the issue is we have an industrial property and we can't enforce the code, is it a business license issue? Do we have something in our local code that says, well, you have to actually be compliant before we renew your business license? I do think the short-term rental registry, or I guess ordinance, seems like that seems to be sort of the caveat to state law is we can have a short-term rental, I don't know to call it registry, but they have to apply to get the permit. It's a permit. That's different from the registry, probably. So just the high level, though, I think the thing I would just raise on this issue being a top priority, and Dan, this is kind of what I've heard the legislature in years past, they say is the solution trying to find a problem. And so if we can just identify what it is we're trying to accomplish with this law that will impact us, I think that we can work our way backwards to see whether this is a true top priority, or is it something that we can already address with our databases, with our current ordinances, with the business licensing system, with the watershed department. I mean, presumably everyone in DeKalb County, certainly unincorporated, has to get a water account, a water and sewer account, which they have to register. And so that's all I'll say about that. Just that, when we talk about our top priorities, presumably that's Dan spending a lot of your time trying to get something done. And so if this is something that truly we're going to be solving, like a whole host of issues that's great. But if there's something that we can do locally within our own jurisdiction that's currently allowed, that might help us prioritize. Thanks.
So, so the question is, what is our intent behind this? I mean, what is the reasoning behind this? And I think you can get through a whole bunch of stuff if we talk about what's our intent, what are we trying to do with this? I would assume we're trying to protect neighborhoods because from my conversations with my constituents, they can't ever find the owner of the property to do what they would like to do about the property. So that's my intent, to locate the owners. So if there's a problem, people in the neighborhood can deal with it because I can't locate it for them. You know, but we can have a source. Would that be something that could go to home rule, or would it have to be something that would,
So again, Commissioner, I don't know that we would need any change in state law just to gather the information that's already publicly available or available to us on our own systems. And to your point, Commissioner, ownership information is readily available to us. We determine ownership of property on a routine basis. If the question is what property is rented, that's a nuanced question and a little harder to get to. And to Commissioner Terry's point, and Commissioner Patrick's point regarding the registration or application for our utility services. The way that currently works, either the tenant or the owner can come in and ask for the water service. If the tenant comes in, a copy of the lease is required. But if the owner comes in, there's nothing additional required. So while our water database may give us some tenant information, where the tenants are the folks who have come and opened those accounts, it's not going to be fully accurate. And for those where it's an owner account, that's not going to give us any more information than what's already publicly available at the courthouse just through title records. So in order to get a full and complete, you can't ever have it 100% accurate, but the closest to 100% accuracy would be through a change in state law that would allow us to require this information from owners. So if that's the underlying intent, to know with as certain as we can what properties are owner occupied and what are tenants occupied, the registry, that change in state law would be our most comprehensive way to do that. We can begin to gather information from other sources, but it's not going to be, and again, we'll never be at 100%, but it would be further from reality.
okay. We are joined by Commissioner Masai. Thank you for being here. Okay, Commissioner.
Yes, ma'am. Thank you, Madam Chair. And I'm just thinking, based on some of the conversation that we've had today, could we, or would it be within our authority to do something similar to what we did with renewal of licenses and opting in to register to vote? When people renew their business licenses, can we automatic opt them into the registry, but they have the option to opt out? And that's something we can start implementing in the interim while we're trying to figure out our legislative approach and opt in with the renewals.
We'll look at that to stay within the law. We may need an opt-in versus an automatic with an opt-out, but I'll look at it and see how far we could go on that. It is, my understanding of the state law is the restriction is on a requirement that you register. So if it's an opt-in, opt-out, that may get us there. We'll look.
Okay. Commissioner Masai.
Thank you so much. And again, please excuse the voice here. So my understanding as it relates to service, which seems to be the ongoing challenge, is that it is possible to serve the Georgia Real Estate Commission when it comes to a property that's, for instance, an LLC and used for the purposes of renting. So like, for instance, if someone has a number of houses, if they put the houses in an LLC and that's the entity that has the ownership and they have tenants in, and say, for instance, they're out-of-state landlords and we have a hard time locating them, that though we cannot effectuate service or might not be able to effectuate service directly to the landlord and trying to find them may be a challenge, that we're able to do so through the Georgia Real Estate Commission, similar to how we do certain businesses, and being able to go through the Secretary of State. So that's something for legal to look into. I had a conversation most recently at Politics and Pancakes, probably about a week and a half ago, with the DeKalb Board of Realtors, Georgia Board of Realtors. That gentleman was there as well. So that's an option also.
Okay, if you could look into that, give us. Okay, Dan.
Okay. So you want me to move on to the other ones? or-
Now, tell us in a nutshell once more the legislation that State Representative
Margaret Oliver passed.
Mark.
So it was to say if you had an out-of-state owner of rental property, let me see, I just looked it up to make sure if it's any more than rental property, operates a single family or duplex residential properties, then they have to employ a broker in the state if they don't live in the state. So there's some sort of in-state contact. So it's not any sort of registration requirement. It is just saying if you are an owner of these properties and you live out of state, you got to have somebody in state so people can contact somebody in the state to address issues. And that's really all it did.
Okay, that's not for legal services, it's just for contacting.
Right, yeah. Yeah, it's
Oh, okay.
to try to improve
Right.
being able to find somebody because of, one of the bigger complaints was out-of-state owners
Right.
who knows where they are. Very
Right.
hard to find.
Okay, okay. Okay, you wanna?
I just wanted to be clear that this conversation, I think, relates to what Commissioner Messiah was just saying to us, that that for service of these folks, if we're looking for a day-to-day contact for code enforcement issues or noise issues, that's a separate question, right? We could, of course, contact a registered agent and go through this process if necessary, but I think that's more designed for when you actually need to serve somebody for a lawsuit or with a citation to bring them to court.
Okay, thank you. And Robert?
And I guess another question for Matt or Zach. Can you guys come back to us with data from code enforcement on how many problem properties they have where they're not able to reach the property owner to fix whatever the issue is? Because I think that goes a lot to supporting the overall thrust of these requests, which is, it's a problem, it's very time consuming. I know from Norcross, when the police department got involved, they were able to do service through police departments across the state and the country, but it was problematic getting to that point. So any data to support our need.
Okay. So that's something that we want to consider as a top priority. Okay.
Okay, want me to move on to the second one on the list on page 1, about tenant protections, and this specific one was requiring property owners to clearly display and disclose all fees, including what are known as quote-unquote junk fees associated with the tenant's lease prior to signature of the lease agreements and in all advertisements. This was something in your legislative agenda from last session, and was introduced and will be pending next year, House Bill 687. And while, this is listed under tenant protections, but certainly item number 8 on the next page, dealing with water billing leaks, to authorize the county to forgive a tenant's water bill and charge back to the landlord in situations where the water bill is in tenant's name and the tenant has provided the landlord written notice that there is a leak and the landlord fails to fix the leak, that could be, you can consider them separate items, or you could consider a one tenant protection item with two bullets, because those are really both tenant protection items. So just to note that. Any discussion on that, or you want me, I can move forward?
Yeah, how was that handled in the last legislative session?
The tenant, the
Tenant
House Bill 687 that was introduced. So that was introduced by Representative Amari Crawford, but toward the end of the session, so it didn't receive any action last session. So it would be, we try to move it forward this session.
Oh, okay. Okay.
Dan, as we go through these items, could you also just help us understand the different associations and other lobbying organizations that might be for or against some of these issues? Because I think when we talked about the apartment complexes, there's the apartment association, and I think in the past they've been supportive of some of these things. But if we could just understand that if we add this to our priority list, are they going to oppose us? And is there a way that in some of these issues we can garner their support? So it's not just GMA, ACCG we're relying on, but all the other potential stakeholders that are at the Capitol that arguably probably have more resources and more money. I think that's something we're going to always kind of come up against. And in terms of the junk, or I guess just because you brought it up, the water billing leaks, is that something that that the law department is looking at in terms of just how we handle? Because it seems like if we have the ability to adjust bills, then it's an internal policy. We simply say, if the tenant has believes there's a leak, like there's a high water bill one month, and they say, oh, there's a leak, and here's the letter that I sent to the landlord asking for it to be repaired, and 3 months later it hasn't been repaired. Presumably that's just something that we decide internally, well, we're not going to penalize you for it. And to Matt's point earlier, if they provide a lease, then we have the landlord's contact. And so it just seems like that might actually be internal. But have y'all looked on whether that actually is a state law change?
So the ability to write off that portion or not charge the tenant for that portion is certainly within our control. It's the ability to go after the owner for failing to institute the fix that is not, as I understand it, currently within our control. So that's part of the ask, is for an adjustment in state law. And as we've discussed in the larger water billing context, we're looking at the ability to either require that the bill be in the owner's name or require that the owner be a co-signatory or a guarantor. And in those circumstances, then we would be able to do exactly what you just laid out, sir. But currently, if I'm the owner and you're the tenant and the bill's in your name, the county has no ability to go after me as the owner. I'm not an account holder.
Okay. But I thought
So that's the wrinkle we're looking at.
Okay, you're also looking at it from the lien perspective. So you're saying we can't have a lien on the property owner for the tenant not paying?
No, sir, we cannot. The lien is based on you as an account holder with us. And so if the owner doesn't open the account, we don't have currently, as I understand it, a recourse against that owner. Our recourse is because of the contract that we enter with that ratepayer.
Okay.
I was just going to add, I think that we also have a challenge in that situation. If the owner refuses to make the repair, at what point can we turn it off? If we have evidence from the tenant that they're trying, they're doing all they can, and so that complicates things, right? Then it's not their fault.
Is that something, Madam Chair, is that something that we could, does the Finance Department, or I guess maybe Urban Legal, be getting data on that potential issue as well?
We'll see how prevalent it is, but maybe this type of legislation could help us to, maybe, I don't know if it would be make a repair and then lien, I don't know. But it's a tough circumstance for the tenant.
Yeah. Okay.
Okay, and I'll back up for a second just to address what Commissioner Terry asked about potential support or opposition to number. I think it may be different on different issues. So 2 and 8, even though they're both really tenant protection issues, there may be more or less opposition or agreement. Because they're two different issues. It could be 2 different pieces of legislation. But I think generally there is usually concern from any group when you're changing the requirements on what their members need to do. So the apartment association probably would have concerns. Doesn't mean we couldn't work with them and maybe come to some workable solution. There's always that opportunity. I mean, some things I can tell that they'll really have a huge problem with. I think we would have to have discussions with them and see where we could get on these issues, but those would be the groups likely. I mean, there are probably other jurisdictions that would be supportive of this legislation. They're not things that are on the ACCG or GMA platforms. They have more general platforms about some housing stuff, but not the specific details that are in either of the 2 of these. Moving to number 3, which deals with annexation and city reforms. So what I did was combined that the first bullet is why it's called New City Reforms, is really that first bullet about the repealing that code section about the sale of parks. That's really more of a issue when there's a new city created rather than an annexation, but it could be also considered for an annexation. And then other items that we've had that have been brought up about annexation, dealing with comprehensive review of the 60% annexation method, removal of barriers to the de-annexation process in Georgia, oppose any annexation advanced to the delegation without county support, and restricts the use of taxpayer funds on consultants for annexation. So these are really items you've seen before in past legislative agendas, and there is active legislation on annexation and cityhood reforms every year at the General Assembly, and likely there will be again this year. And it's always something that's on ACCG's list as a top thing they look at, and then the Georgia Municipal Association is usually opposed to all of these efforts, and small steps have been made to try to put counties on a more equal footing over the past few sessions, but very, very slow incremental stuff. So that it's going to continue probably along those lines for general legislation to come. But it's always, an item that you all have had out there. And so that's this item. And that's usually, it's pretty predictable, the discussions and the testimony that will occur on those items down at the legislature, although, there are more people who have experienced in their own districts outside the metro area now some annexation efforts where the constituents were not very happy and wanted to stay in unincorporated areas or stay in the county. So that's changed some of the dynamic of who supports some annexation reforms and cityhood reforms too. So that is that item number 3.
Okay.
Thank you, Madam Chair. I do support this being a top 3 priority. I do think that the overall issue, particularly the 4th bullet point, oppose any legislative annexation advanced to the delegation without county support. I think that is fundamental. And I would even argue from our perspective as an existential question about the purpose of DeKalb County. Because if there are efforts underway that would allow existing cities to dramatically increase their size, then that is something that should be discussed certainly with all of the county commissioners. If it's not ready for a public discussion, I think it would be really important for individual commissioners that might be impacted by strategies to be briefed early on, because this is something that is very controversial. And we know it just comes down to the money. And if funds are being potentially restricted, whether federal or state, whether through budgetary rescission or just policies, then the natural inclination is for local jurisdictions to seek other funding sources. So counties can't seek other funding sources in the sense that we cannot annex another part of another county. Cities, however, can simply look within the county. And so it's not a zero-sum game. I mean, we still have the general fund, there's still county-wide services, but to the extent that DeKalb County is a full-service county that does everything that a major city would do, any erosion of that ability to fully fund those departments begins to whittle away at the rationale to even have those departments. And, this is something, unfortunately, we heard one of our cities is already, despite saying they're going to be a low service city, they're already deciding they're going to begin to look into expanding their own services, which will be at the detriment of our existing services, particularly stormwater and police. And so I think we have to be very clear that if there is some sort of grand strategy that we're all going to set the boundaries and we're going to just agree to stick to those for the future, we should do it in a way that's at least proactive and not surprise anyone at the legislative session with some new map that we've never seen. And then now we have to go to the delegation as commissioners and say, well, we actually need to work this out. So sorry, I'm being so circumspect there, Madam Chair, but I think this issue is just fundamental to why we exist as DeKalb County government. Thank you.
Okay.
So moving on to number 4 is next gen 911 funding. And I think I'd mentioned before that there is a study committee looking into this issue. This is a huge priority for ACCG and will probably be one of their top 3 priorities is funding for those systems and funding for 911 systems. However, we're a little bit more particular too on where we'd like to see that funding go. And one is about investing in a real-time crime center and state-of-the-art emergency systems and technology solutions. And I've had a conversation with Mr. Welch about confirming, because the law for 911 funding talks about it can only be used for that. And so we're trying to look at it to make sure that something like a real-time crime center, what would be proposed in DeKalb possibly, would fit into the current definition. Because if you get, really the study committee and everything is kind of looking at trying to figure out a methodology for how much the state funds, how much locals fund, and coming up with a proposal for that. But we would also want to make sure if for some reason the language in the general law about where funds can go doesn't include something like this, which it probably should, and it may already, that we want to get that kind of amendment into what's ever being done, or if we have to do it on our own. And I don't know if you have.
Yeah, so this is, you're seeing real time. This is how Dan and I communicate. He asked that question, and Michael Petty, who's here, who did all the legwork for the law department, kind of give him a shout out, is here with us as well. He looked at this 911 question, and Dan is exactly right. There are some broad categories that lay out how that money can be spent. We think most of the functions of a real-time crime center can be seen to fit within those allowances, but I think the cleanest and safest thing for us would be to simply have it added as a category of allowable expense, just to crystallize and remove any doubt. So we would recommend this one stay on. If it doesn't move, I do believe there are ways, again, that we could fund most of the purposes, adding Next Gen Crime Center and certainly a real-time crime center and the Next Gen 911 out of the fees we collect. But as I understand it, again, we would like it clearer that that's allowed and potentially to solicit the state for some additional funding.
Okay, I think Martha had something she would like to say.
Yeah, so just a little bit about what we already have funded. So we put $8 million into our EZNet system. That's for 911. So we already have everything prepared for Next Gen 911 as it goes statewide. So we want to allow flexibility of the funding as we move forward, because this is going to be, at least to start off with the foundation, about $17 million. And so the state has to fund that. So what we want to do is say, okay, well, we're ready for you guys to, we're ready to integrate the system because we have the EZNet system. Now, can we allow for flexibility? We have all these other initiatives going on. That's kind of the purpose behind what we're doing. So we are supporting, what this states is, we are 100% in, and we're supporting you guys in setting the foundation for your Next Gen 911, but we want to allow for flexibility of those funds, and this is what we're doing next, and we're prepared to integrate into your EZNet.
Okay.
Thank you, Madam Chair. Is there an example of an area of flexibility that's being requested?
No, we would actually be implementing language. So we would be the first ones because their focus is statewide. There are current, like the city of Atlanta already they've been running their EZNet system for a long time, which allows for photos, pictures for police officers to have, just overall more public safety. So what we're doing is we're implementing these $8 million to DeKalb County already. So we're just adding on. We just need additional funding for a real-time crime center. I mean, ultimately, that's the goal. But no, there's nothing currently in place. It's too early.
Okay, I mean, that would be helpful as well. So whereas we're being asked with the allocation in terms of some flexibility, if there's an area in particular where it's been identified, there's a need for that flexibility,
Oh, yeah.
that'd be helpful.
Yeah,
Thank you. I'll get back to you, Madam Chair. Thank you.
Okay, Dan, and understand that we have about 35.
Okay, I will move on. And just to clarify on that 911, I mean, at the end of the day, what we'd have to do is draft specific language so we know what to put in there. So that would really demonstrate what we're trying to do, because without the language. So number 5 is just a very general statement: behavioral health funding, which is support increased funding for DBHDD services, programs, and initiatives.
Okay, Ted.
Thank you, Madam Chair. Yes, I'd like to propose potentially reframing this issue, whether on our document or how we approach it in the legislature, because I believe that this actually fits in, interestingly enough, to what the federal government is positioning their policy around homelessness for the foreseeable future. They have made 2 general, I think, policy statements. One, if there's an encampment out there, it should be dismantled and anyone there should be arrested. So in other words, the federal government is saying criminalize homelessness to the extent that the law would allow, and or potentially tying grant funds to certain policies. So that's concerning. right? Now, on the other side of things, they have said, but we want to see treatment. And when you talk about treatment, that's actually a system that we, I think, are already doing and actually could support the overall effort to get more behavioral health funding. And I think this is in two ways. It's through the Crisis Center. This is something that the county has set out our own funding goals, but we need additional funding for the Crisis Center and a diversionary program. And the manifestation of that would be a diversion center. And so I do believe that there's actually a potential consensus here that can say two things. We need crisis center funding and we need diversion center funding, and those actually can be the same thing. And it's something that I've asked Claritel to work up additional architectural sort of, schematics that would simply suggest that a new crisis center could actually serve as a jail diversion program for individuals experiencing homelessness who have an underlying mental health diagnosis, which we do know from anecdotal experience and from the data that some individuals are going to jail and that's how we're housing them, and or they could be going to the crisis center. And particularly the persistently homeless, folks who have been out there for 5, 10, 15, 20 years, there are underlying mental health issues that could qualify. So I think committee members, what I'm really suggesting here is that we sort of reframe this title and this statement to include addressing homelessness and addiction treatment. And I believe that actually would align very much with what maybe some Republicans are saying at the Capitol. I mean, everyone's talking about Atlanta, the World Cup, the Super Bowl. We got to clean the streets off, right, is what you're saying. And so if we're talking about funding, I'll submit that we should accept that frame and then focus it on where the funding is needed, which we think will actually make the biggest impact, which ultimately is don't send people to jail, send them to treatment. And Commissioner Patrick, I think, has been leading on this with the resolution on diversion.
Okay, did you have something to say?
Oh, no, I just had a
Okay.
thought on how to state it, that's all.
Okay.
That's a really good point, but I do want us to be careful with heavily associating homelessness with behavioral health, because we have a lot of unhoused who do not suffer from behavioral health issues. Recently, in the past couple of months, when I visited, for example, Frontline, that was one of the concerns I heard from the folks that are being serviced there. Like, they have other issues surrounding their situation, and there's no bucket for them to find extended or wraparound services of support, because the assumption is if you're unhoused, there must be some association with behavioral health. So I do want us to be careful with that if it's combined in any way, it might need to be separate bullets, but I don't want to isolate or negate support of parts of that community because we're making those assumptions. So I do want us to be cognizant of that.
Okay. And I'd like to follow up on that because I definitely support what you're saying. You're seeing a lot of homelessness now because of economics, and because of policies that are put in place by governments, including our own, not DeKalb, but state government. So, and there's so many entities that are focused on homelessness because people understand that that is an issue. One of the things that I want to get away from is identifying sources that we're funding. Because when we identify one source that we're funding, somebody else is going to come to us from another source to say, let's fund us. And, and that's the reason we go through a process where we have different funding needs for different things. You have a bidding process. So I don't want us to identify any particular source. We can identify the problems and say we need to look at that, but not a source, you know. But I agree totally with what you're saying, because it's not all, that's a component of it. But I would think a larger percentage, if not now, it will be the economic impact of what's happening in society today. Okay, so go on now.
Okay, so item number 6, dealing with tire waste cleanup reimbursements. This would amend the law for reimbursement from the Solid Waste Trust Fund for projected costs associated with tire cleanup in hard-to-reach areas, not just based on individual project expenditures, to include reimbursement to support municipalities within counties when service delivery is governed by an existing IGA, and authorize additional funding for counties with populations exceeding 500,000 to support large-scale or high-frequency tire dump cleanup efforts. And you would think that those who would, other counties and cities that would benefit from this would be supportive, probably environmental groups as well. The rub will probably be more from the funding that has to, the agency from Natural Resources or EPD that has to provide the funding. I don't know that there'll be necessarily lobbying groups that would be against this. I know several of you on the Board of Commissioners have been working on tire issues. The CEO's office has. I know Mr. Allen has done a bunch of research, so if he sees anything that I don't, as far as any opposition or whatever, but this is something that's really, I think others would be interested in, but I haven't seen much on it except for DeKalb has really been a kind of a leader focusing on this issue.
Okay.
Just anecdotally, Commissioners, I attended the Georgia Environmental Conference on Jekyll Island about 2 weeks ago, and I attended a EPD session where they were touting this program and the success of this program statewide. So I believe that they would certainly be supportive of expanding funding and easing access to the program, which I understand to be the main concern. So I think there will be support at the state level.
Okay. Yeah.
I think I'll be hiring him to come down on the lobby. Okay, so moving on to item number 7. This is about meetings by teleconference and expanding it to authorize all agencies as defined in the code section to hold meetings by teleconference regardless of emergency conditions. As I put in my comments there's really been no appetite at the General Assembly to expand this to elected official boards, especially like the Board of Commissioners. And even when this issue has been brought up, and it's been brought up in some ACCG policy committee meetings, there's been, and even this year, there was a back and forth between commissioners about whether the ones that didn't like it said we should be at all our meetings in person. So it's a tough issue when it comes to elected bodies. However, for agencies, a couple of years ago, there was several agencies that got exempted and were able to meet by teleconference or video meetings. And this last year, we were intimately involved because one of our items was trying to get CSBs to be able to do it. So we got that bill passed, and library boards was also part of that, although they were a little tougher this year. And it was mostly dealing with the library boards, not the CSB boards, the people who were bringing the library board piece. Some did not like the fact that the library board could just meet virtually and that they should be in person. So the compromise they came up with is 50% plus one had to be there in person, and then the others could be there by teleconference. So, because a lot say, well, the issue is a quorum issue, so they thought that this would help with the quorum issue while not allowing to be 100% virtual. But there's, other ones that are not under that allowance right now, so there's probably a chance to expand that because you've allowed the library boards, the CSBs. We put in something for the retirement pension board on the development authorities, I think, are included in the law now. So there's several that are. So we just need to figure out which ones are not, because I think that's one of the things this was pushing. It was pushing for everything. But like I said, I think there's going to be significant pushback from some legislators again regarding elected bodies. And, ACCG couldn't even pass something saying that they supported it because there was a split between commissioners on whether that should be included, and they didn't ultimately include it in their platform.
Was it more rural, urban, or was it a mixture?
It was a mixture, frankly.
Robert was first.
Thank you, Madam Chair. If possible, I'd love to keep pushing for all, including elected officials, but we have a couple of boards where they are going away from being virtual to in-person only, and that affects the people that I've appointed on those boards. So if there's a way to have the language that includes those boards in particular, and I know statewide there's not a, utility billing, utility billing, water. Thank you, water billing board, but boards similar to that are perhaps advisory in nature, if there's a way to push for all, but make sure we get the advisory boards put through on that. Commissioner-created advisory boards.
And I think that's a good distinction that we can focus on if we get traction in one direction and
Right.
not fully.
Right. Thank you, Madam Chair.
Okay, we already talked about number 8.
I still had a question.
Oh, I'm sorry. Yes.
And just to get a bit more understanding about why folks may have reservations about it, is the assumption or implication that because some of the jurisdictions don't meet as frequently as we do, then they see a sense of necessity for the in-person meeting because they don't come together as, I've heard we meet more than anybody else. So there's a need in DeKalb.
Yeah, I think it's around that people want to be in the same room as their elected officials and want to be able to, if they're delivering their public comment, be able to be looking at them rather than over a screen, and that they feel maybe, what comments I heard was maybe it wasn't as effective to give public comment over Zoom as it is from like a podium.
So this is just for the business meetings then, not for Cal?
Yeah, I mean, that most places I don't think have meetings necessarily like the Cal, where there is, I think they, like you said, have less meetings, and all their meetings involve public comment and input. So, I mean, the way the law is right now, all those meetings have to be. Now, could you do some exception where there's a meeting and there's no votes being taken? I mean, that's kind of a nuance to maybe what you're getting at there. So where there's no public comments and there's no action being taken.
Briefings.
Okay, so, I just want to say that, I just want to say we're going to hear real quick, we're going to hear quick comments from everyone that I understand. I mean, people elect their officials and they want them to come to their meetings and they want us to be in person. And so, although it may be inconvenient for us, that's what we elected to do. And so I'm for one in support of some meetings being via teleprompt communication. But I do understand the public's view is that if they want to talk about Commissioner Johnson, they want to look me in my eye to tell me what they want to say. And, and they should have that right because they elected us. But I agree if we can have some on video or Zoom or whatever platform, I would prefer that. Okay, quick comment.
Yes, quick comments. Yes, I agree with my colleague's comments. I think there's sort of a nuance there, and maybe that's where we can hone in on, we're not impacting other counties like holistically. It's here's specific things that DeKalb does that might be sort of specific to us. And so if there's a way, Dan, to help tailor potential legislation that's very specific, I do agree with the idea of, like, you know, the elected officials attending the meetings, but then if it's a hybrid option as well. So I know that's kind of like a very, we could slice that a bunch of different ways. And then maybe one request just for our own data, as the law department and the central staff are sort of going through the list of all the boards that we have, are y'all able just to simply have a little line that says meets virtually, can meet virtually, just so we know exactly what boards can or cannot do that?
Okay.
Thank you, Madam Chair. Just to follow up. So when I put this initial idea forward, it was because our zoning meetings had such high attendance rate. And I think one of our zoning meetings had 450 online residents attend. And we have not had that. I've not had that in my experience from municipal. And in person, I don't think we've ever had 450 people in a building for that.
Accommodate them.
We could not accommodate them. So the notion of really this was focused on the zoning components or the zoning meetings that we have. If those could be done by Zoom, really we're getting more engagement from our residents, which is at the end of the day, they can yell at us in person or they can yell at us over a screen, but either way, they're still getting in touch with us and communicating with us what's on their minds so that we can pay attention to that. So that was, just for clarity, that was the focus, really was from a zoning perspective. If those could be held remote, and acknowledging that I think we have 6. Thank you.
Okay.
Just briefly, and thank you, Madam Chair, just based on the code section in which sharing, in terms of the meeting, it seems to focus more on those issues that will be voted on our meetings, particularly where there is a vote or a contest. Agency action is what it says. So if we're talking about a CAL meeting, if we're talking about a committee meeting where there's not going to be a specific vote, then maybe we can carve something out in the language where if there's not going to be an action voted on or actual contest, that would allow for us to have it take place via teleconference as an option. With that, I yield back to you, Madam Chair. Thank you.
But what Commissioner Patrick said about zoning, I think is a good point. Because you do have much more participation in zoning matters by Zoom and telecommunication than in person. Okay.
Oh, no, I don't think your microphone.
Uh-oh. I'm sorry. I'm sorry. Everybody be telling me my mic is not on. What I was saying, what Commissioner Patrick was saying about Zoom, telecommunications, you do have a much larger participation for zoning on Zoom than you would have at a regular meeting.
Okay.
And our capacity is limited as well, so you couldn't get 400 to 600 people. And I mean, with the renovations, can we get 400 to 600 people? No.
About
Okay.
220.
So, Madam Chair, on that point, and I don't want, and the county attorneys can slap me down if I'm incorrect about this, but I remember, since this has been around for a couple of years, one of the discussions we had in the past was that there's the only reason that you couldn't have a hybrid meeting where the commissioners are there under current law, but if you wanted more citizen participation, so citizens could either participate in the room or they could call in online like they did, it was an issue to hold a virtual and live meeting if this was a hybrid meeting because of the technology restraints in Maloof. So I don't know if legally, I think you can do that. He can tell me if that's wrong, but I don't know currently with the remodel of Maloof if that would be possible.
Dan's 100% correct that under the, our understanding of current law, as long as a quorum of you all is present in the room, the meeting can move forward under current law, and you can allow people to call in for public comment, public hearing, etc. We take some slight adjustments to the rules in the Blue Book. You'll recall during our remote meetings during COVID, we made an allowance for folks to email in comments. We would need to make some adjustments like that. But my understanding is that there were technological limitations expressed by Mr. Metelsky, and so we did not go to that method of allowing remote participation even when you all are present in public. But just to reiterate, the restriction in the state law, there must be a quorum of you all present in the room for the meeting to take place, present in the room for you all to take place, and for the meeting to take place. But then there is the allowance for each of you, two for illness or absence from the jurisdiction per year, okay? So that's the nuance, and I think we're looking at two different things. One, the ability to hold more remote meetings, period, without a quorum in the room, but then secondarily, or as a second piece, this desire to get more public input, which again, I think, I'll review it, but my understanding is that that's allowed under the current law, as long as there's a quorum in the room, but there were technological issues. I think those will be addressed by the
Build out.
redo of Maloof, just to be clear.
Thank you. And so, this particular item 7 would require us to hold teleconference meetings without a quorum. Is that what this is saying?
So number 7 would basically there's state agencies can do it,
Yeah.
and local governments can do it, but only under emergency conditions. This would put you on, if agencies and the board were able to do it under that law, it's basically what you're allowed to do under emergency conditions, you'd be able to do under any conditions. But for the specific example of just allowing people to come to the zoning, that wouldn't require a law change at all. It's really a technology issue, and I think as Attorney Welch said, just make a little change to your rules.
Have you already addressed 8?
Yeah, already addressed 8, so I can move on to number 9. This is the marijuana ordinance reform, which would provide parity between counties and cities, because cities can already do this, regarding the authority to adopt ordinances to regulate the possession of less than 1 ounce of marijuana. As Madam Chair knows very well about this proposal, it is still remains in the ACCG legislative platform. They kept it in. It is not being recommended as a priority, but it's still in their platform. A bill on this issue was introduced and is pending in the General Assembly. And we worked with the law department to make a couple language changes that may allow a better chance of trying to advance it this session. But yeah, this is one where ACCG will support us, but we're really gonna have to take the lead. I think maybe we could get some other counties. I know that Madam CEO has definitely been working with the leaders of other counties. This might be an item where we can get some regional support for doing this, and that might, help us with some of the other big metro counties getting involved as well.
And
Anytime down there, even when it comes to the medical cannabis and everything, there's a whole group that pushes back on anything that has anything to do with it, and they don't sometimes even pay attention to really the details.
Right.
And then there's some in law enforcement, as you saw when we got it on the ACCG agenda, that have their concerns too. But yeah, I think it's worth keeping on there.
Okay, thank you. Yeah, I'd like to keep it on there. Okay.
Madam Chair, I think it should be kept on there. Perhaps a suggestion might be, I think there's only 15 or 16 counties that have a police department. And that might be the end point. We're not asking statewide. We're asking for counties that have their own police department to be able to have this ability, so that there's no distinction between the municipal and the county. And that might be the might be the way to slide it in there.
Yeah, you know, I mean, it's already in municipal courts. It was once, we had a recorder's court, and with the recorder's court, we could have it here. But for whatever reason, Matthew, if you could sort of generally say how you would tweet it to make it better.
So the language that we've provided this year simply references the restrictive code section and doesn't reference marijuana or any other controlled substance by name. It simply creates a cross-reference and allows the same flexibility as allowed in the municipal courts.
Oh, okay,
And that's all it does, just as a
Okay.
cross-reference for clarity.
okay.
Quick comment, I do support this staying in our top 10. And maybe just to Commissioner Patrick's point about the 15 counties that have police departments, just help us understand, Dan, or, you know, the research of which ones have a municipal court in their counties. Or we used to have a recorder's court, which in essence was our municipal court, but that changed several years ago. So that was part of the discussion, is do we bring back the recorder's court, which then I believe would actually allow us to have parity without a state law change. Now, I understand recorder's court and bringing it back as a whole ball of wax, so it might not be worth it. In the effort to get more data on this issue, I did reach out to the state court, which is required to hear these issues, at least in certain aspects of the law. And the state court has said in the last couple of years that they actually have not seen any standalone under 1 ounce possession charges brought to them. So it suggests that either our police and or the solicitor are sort of handling that in their own way. And so the goal for the upcoming FAB meeting, Madam Chair, is just to get some clarity on how the Solicitor General is treating that, along with, you know, DeKalb Police, and how that's, because it looks like some of these aren't making it to the court system. So there might be another way that we can continue to support that parity goal.
And, you know, I would just say, you know, I wouldn't want it to be in control of who's handling the department. Because you see what that can do on the federal level by having discretion from the person in charge, you know. So I would like to see it in the books, no matter who's in charge. This is how it's dealt with. And so thank you, Matthew, with the recorder's court. I don't think we'll bring that back. I mean, it's a cost that we don't have to have. And then we have the 4 traffic court judges that take care of many other things that was handled in recorder's court. And so that's a cost I'm sure the administration didn't want to see. That they would like to fund right now. Okay.
Okay, and the last one on the top 10 is the community service aids. So you would authorize within the powers for community service aids the ability to handle minor injury and property damage accidents. This bill is also within the ACCG platform. Public Safety Committee for ACCG didn't put it on their priority list, but it remains there. Likewise to the marijuana ordinance reform, I think you could get a lot of especially in the metro area. Local government's on board with that. And a bill was introduced on that at the end of last session, House Bill 915, so it's one of the last bills introduced. And so as far as, opposition, I mean, there might be some in the law enforcement community, but this is an optional thing. It's an opt-in. It's not something that's required. So if you want to do it in your jurisdiction, they shouldn't have an issue with that. And that's something that just have to drive across, that this is not mandatory statewide. It just gives the
Right.
particular local government the option.
Right. And of course, if we have an accident, especially in the metropolitan area, we have to wait 2 to 3 to 4 hours for, if it's a minor accident, for police to arrive. So I'm sure that this would help not only police, but also our constituents and citizens in the county. Okay.
Thank you, Madam Chair. I totally agree with what you just said. And this is something that when I was on the ERPS committee last year, we did hear from DeKalb County Police Department basically requesting this change. And so that was something that I'd worked on. Thank you to Dan and Captain Albritton, who attended the policy meetings to convince skeptical commissioners in the ACCG that this made sense. I think the opt-in was a key piece. I also think having the police department through Albritton there really helped, because I mean, here I was saying it's a great idea, and then they're like, well, you're not an officer. And so I think if it's okay from the administration and Dan, the legislative strategy that I would like to work on is just identifying the appropriate committee or committees at the House, I guess, and Senate, any opportunities to visit with those chairpersons of those committees with the DeKalb County Police Department participation, so they could just simply say, here's something that would help us do our job better. We want to get back on the street addressing violent crime, as opposed to having to do the paperwork, which in essence what this is handling minor energy and property damage. I think the statistics are pretty straightforward. This would save thousands of hours of police time to get back on the streets. Hopefully that aligns with some of the public safety messages that are coming from the majority party. So hopefully this is something that we can agree on that would be bipartisan. And then, Madam Chair, just in this vein, I think we talked about at the legislative workshop retreat that if individual commissioners have sort of specific priorities that we should feel somewhat at liberty to work with Dan and the administration to put in our own time to try to help advance some of these priorities. So it's not just Dan down there. It's Dan with the support of the different groups that we're dealing with. Is that okay to put forward as a strategy?
Well, I'd like to get Dan's opinion on that.
Mike,
Oh, yeah. I'd like to get Dan's opinion on that, because I always feel when you have a coordinated effort in trying to do what you're trying to do, and you got people coming in from left field and right field trying to do the same thing that you're doing, can that create a problem? I mean, and I'd like to hear your comments on that, Dan.
I mean, I think as long as it's a coordinated effort,
Okay.
and I think it's kind of a case-by-case basis. There are certainly times when it makes sense to have hear from an elected official rather than just from a lobbyist. Definitely on some issues, they really like to hear from the elected folks or even staff folks who are experts in it, rather than my face who they see every day. So it's really case by case and coordinated is what I would say, really.
Oh, okay. Okay. Yeah, so just so they listen to you in a
Yes.
coordinated fashion,
Can I?
you know?
Can
Okay.
I offer one thing, Madam Chair? If it's the will of the board to do that sort of thing, it would probably be very helpful, during regular check-ins at ops or something where it's discussed, here's the major things that are coming up and here's how we are going to handle it. So
Oh,
that
okay.
everyone is clear, because there may be times where it's necessary, maybe times where it's helpful, maybe times where it's not helpful.
Right, right. And that was my concern. Because you don't want everybody to be bringing in stuff that you would think you shouldn't do.
I'll stay firm softly.
Okay, but I like that, if you could bring it in, if you could coordinate with me as ops chair as well as that. Okay, and,
Madam Chair, just a suggestion I've made in the past, as we have the legislative lunch with our DeKalb delegation, perhaps having something where we extend it to the committee chairs at the state level and just meet and greet with DeKalb County Board of Commissioners and hear our concerns, and maybe they can share some of their concerns, and we build that working relationship that we'll need to have to get some things across the finish line as well. So just making that push again.
well, I would say you build your own relationships. I mean, you know who's in your districts, and I know all of the
Yep.
people in our delegation, and I reach out to many of them.
Well, I was suggesting the other side of the aisle. We probably need to engage with them so that they don't think we're kind of off on our own island with these ideas that we come up with, when really, because we have such a large population, a diverse population, many of the issues that we deal with, maybe not what's happening in rural Georgia, but it's coming as population in Georgia grows. And a good indicator of that, or in my mind, is several years ago, Glenn County adopted an ordinance about homeless panhandling. Nowhere near a big population center, and yet that's a concern that they're having. And so if we look at it from the perspective of DeKalb is actually perhaps on the front end of a lot of issues within our country or within our society to make things work, this is an opportunity to talk with them and reach beyond that partisan divide and say, this is a real world issue. How are y'all going to react when there's a homeless encampment by your
Well, I'm not
interstate?
saying that, but now you're saying for us to all get together at a luncheon with the delegation prior to the legislative session.
For the DeKalb delegation, yes, but also maybe have one that talks about with the chairs of the different committees at the state level. So not just a DeKalb focused one, but hey, everyone out here, this is DeKalb, and we actually have real world concerns that could be affecting you in the next few years.
Okay. Okay, well, Dan, I appreciate you getting through this by 10:35, and we got a couple of more quick questions, comments, and, okay, Ladina?
I did just want to go back really quickly to the question, Ted, that you had about marijuana and the solicitor's approach. During COVID, she made a public announcement that she would not try any of those low-level cases where they could not, essentially, police officers can't go in and measure how much THC is in the plant. So there's no need for her to try because of the ambiguity. And I think that's something, because there's a federal threshold of 0.3 below, it's just hemp. 0.3% THC and above, we can call it marijuana. But maybe that rationale to where officers can't accurately measure and confirm whether it's hemp or the actual regulated drug might be an argument we can use when presenting this ordinance reform. So I don't want us to forget about the science, especially when a lot of the data comes from federally, and we use that as a guide to the reforms that we put in place. But just wanted to make sure I mentioned that.
Thank you so much, Madam Chair. Just briefly, one, to quickly touch on what Commissioner Voltaire piggyback, if you will, in terms of the local ordinance with marijuana. In terms of testing, we don't have that lab for testing set up, which creates a challenge because it's being sent out and then getting it back. So maybe this is, a reason to push to try to see if we can coordinate getting a lab for testing. That's something that's been conversation with the medical examiner and the like. But then also to go back to the community service aides. I mean, I like the idea that they have 280 hours of training, but as it relates to the training and their function when it comes to lower level accidents, they still would need, and I think we need to put something in place from a legislative, perspective, their ability to be able to testify, be a witness, because you still have the introduction of a report. So that's going to be something that's important, particularly if we're talking about accidents where we don't have an officer coming out. If they're going to be doing a report and address the situation, they have to have the capacity, and I'd argue, of course, the training to be able to be a witness if called to do so in the court of law. And just wanted to address those two things, and I appreciate you. Yield back to you, Madam Chair. Thank you.
Okay, thank you.
So, Madam Chair, that concludes the top 10 list of priorities, objectives. The support statements, which are on the next 2 pages, I won't go into that. You all can feel free to review that on your own. Basically, BOC Central staff put that together with all the other items that were presented at your work session that were on the top 10 for commissioners. But I know I looked at it with Mr. Manson, so either Mr. Manson or I would be happy to talk to any commissioners that have questions on those, but they're hopefully mostly straightforward. And those would be part of the overall platform, but we'd really focus on these top 10, presenting them to the delegation and other people at the General Assembly. So I guess the next steps for you all are, if you wanted to designate a top 3 or whatever, if you just, I guess I will leave that up to you if you want recommendations from me.
When does this need to be voted?
I guess as soon as, I think that from the timetable that was put forward in your, the work session and the board retreat document, I think we're trying to meet with the delegation hopefully in October. A lunch in October, so.
So if we had another ops meeting, which would be next week, we would be able to vote on this agenda, give everyone the time to digest, to give their input, and vote on it at the next ops meeting. I'm sorry. Oh, I'm sorry. What did you say? Okay. Our next ops meeting is not this Tuesday, but the next Tuesday. The 16th. And so if we could give the ops committee and the other commissioners time to give comments and get ready for a vote on coming out of ops on next Tuesday, then the following Tuesday, we could vote on it. Would that work?
Yeah, I think that works. The CO's on. Okay, yeah.
Okay, Nicole.
Thank you, Madam Chair. Just want to address just very briefly, as we were talking about deciphering what the top 3 would be from the top 10, and as it relates to the support statements, not going into those, there was a support statement related to the MARTA discussion. That's number 1, MARTA funding reform for capital improvement projects. But I'll address and mention that it's not listed in any of the items receiving the top 3 priority votes, though it was listed as the policy suggestions top 3. So for V1, we've gone through all of the others, but we've omitted MARTA, and it's not listed as one of the top 3 priorities. So I think that we very much need to make sure that that is included, receiving the same level of interest as some of the other issues that we're dealing with, including E911, tires, annexation reforms, and the like. But it definitely, public transportation and MARTA needs to have its due place for concern, listed amongst that 10, since it is a concern
Okay.
mentioned.
And with that, is my understanding that the top 10 was selected based upon our meeting, our joint meetings with the,
Yeah, so that one falls under the methodology
yeah.
pending further review, which is why it's not on there, because it was needing further flushing out, I think, of the method to accomplish it, whether it's state legislation or discussions about the amendments that are not state legislation, are stuff that's like a negotiation between them and the county. So I think it was hard to put down there because it wasn't quite clear the method to accomplish it, or the method that the CEO and the board wanted to accomplish it yet. So she certainly didn't want to take it out, but didn't put it on the top 10 because that's just why it wasn't put in the top 10.
So, Matthew, can you send us information on that prior to next Tuesday? So that we will know whether it should be on this agenda. Is it something that is negotiable, that we could deal with MARTA as a county?
I think part of the concern, ma'am, is exactly what is being requested. So if the request is that the DeKalb increment, so to speak, the money we give MARTA, that a certain portion of that come back to the county at a defined level, that's negotiation with MARTA and the other jurisdictions who would have to approve any change to the current agreement. If it is to put into state law that money must be spent in a certain way, then we're in Dan's shop and we're down at the legislature looking for that change.
Okay,
So
so
it's
if you
partially
talk-
a question as to what the intent of this is, because there used to be a state law that said that the MARTA, every penny MARTA had to be split 50-50 between capital improvements and reserves, I believe, or operations, I apologize. And that state law was repealed. Okay, so now how MARTA spends its money is largely governed by agreement between the parties. So again, the question became, what is the angle that you are asking us to go from? Because if it's simply negotiating with MARTA that the current money we give gets spent in a different way, that's what it is. It's negotiations with MARTA and the other participating jurisdictions. If it is state law mandating that money be spent in a particular way, then again, we're back with Dan. So I think that was part of the clarification necessary from our end.
I'm of the opinion that I prefer negotiating for the by the cab with MARTA rather than allowing the state to determine what the cab receives from how MARTA spends their money. I'm sorry.
Yeah, I was gonna say, because what was proposed.
How MARTA spends our money. Yeah. That's right. And so I would prefer negotiations than the state to determine.
Yeah, so what the CEO had shared during our retreat was half of penny, specifically of the percentage coming back So that would then fall under negotiations. However, if there's a requirement for that, half a penny to go, for instance, into the unincorporated areas of DeKalb, then that's something entirely different, and that would be more on a state level. I mean, particularly where you got, I think it's like 46% unincorporated.
But do you think the state's gonna look after our interests?
Well, no, and that's exactly the point. I completely agree with you, but whereas we have enabling legislation that's in place to ensure that that happens, I think it's necessary, because we can agree that in this length of time, and I think it's till 2056, our constituents will continue to pay that money and that tax. And still, we're at the same place we've been 30 years ago.
So are you suggesting that it goes through the state?
I am. I'm suggesting that we build that out, because to Dan's point, in terms of not having the specific language, for instance, when it comes to behavioral health funding, we have general information, and then the comment says it's, support that may have detailed requests, but it's not as detailed. So I would just like to see the emphasis on public transportation and MARTA be duly placed where it's supposed to, that we iron those things out, and that we're provided with something ahead of ops so we can stay in line with the deadline that we've set.
Okay, so what I suggest is that you send a memo to the board as to what your position is, so that we can consider that for the next ops meeting. And right quick. Okay.
Yeah, just in the effort of narrowing down, because I think Dan was sort of saying what are the top 3 within the top 10. So it seems that now that we've taken the larger list, narrowed it down to top 10, that we should do a new survey that just gets all the commissioners' input for the top 3 within this top 10. Does that make sense? So it's just now we whittled down the list. Now we need to whittle it down a little more, just so we have the top 3.
Okay, John, you got that?
I think that's,
Okay.
Yeah, I think that's a good suggestion. Okay.
My question is also regarding the top 3, but I just wanted clarity about number 1, the comprehensive property ownership database. If we find that we can do the opt-in, which will allow us to update information annually with the business licenses, are we going to remove this one because we can affect it locally and make room for another item to be a part of the top 3?
Matthew,
I'm sorry. Which one?
For the rental registry, if we determine that we can do the opt-in because, it will allow us to update information annually with the business license renewal, is that goal to remove that so that we can make room for top 3 priorities that can only be affected through state as opposed to something we can do locally?
Sure. Again, that would be up to you all. I don't know that the opt-in or the opt-out would still give you all the information you want,
Okay.
because again, people could opt in or opt out. So if the ultimate goal is to allow us to require that registration, state law is 100% required. Again, we can piecemeal some of that information through the back door, but the way to get it closest to reality is to remove the restriction on our ability to require the information. So
Okay.
I would suggest it stay, but that's y'all's determination.
And also, if what is being pushed at the state level, say the bill that Georgia Municipal Association was mostly behind, is broader than what we need and is therefore harder to get done, we could break off and do something more smaller and focused to get exactly what we need that could possibly be more palatable.
Okay, gotcha. Yeah, it can stay on.
okay, well, thank you all for coming today and participating in the special call-out meeting. I think we got a lot done today. So what we're going to do is any suggestions, recommendations, put them in a memo, send them to all of the commissioners plus central staff and legal, so that legal will have it, and also Zach, so that Zach will have it as well. and what Commissioner Terry stated. Let's vote again on what we would like the top 3 to be. And with the language that Matthew and Dan has talked about with the register, because I think it's important to have that background when we make that decision. Okay, well, is there a motion to adjourn?
So moved.
Second.
Okay, well, this meeting is adjourned. Thank you all.
Aye.
Oh. Is there a second?
Second.
Okay, all in favor?
Aye.
Okay, so we are formally adjourned.